Bill of Rights, 1688. Now, if we were to stake our interpretation of the Bill of Rights 1688-89 on the research of historians alone, such as David Starkey, and man, that guy can articulate a subject well, can't he? I mean, I sure wish I could simulate some of his power. Anyways, continuing on with the Bill of Rights. If we did use the historian's view, we would most likely arrive as to the reason for the Glorious Revolution was to admonish the power of the Roman Church over the people's right to choice, to solidify the rights of Protestant religion that gained sympathy after Queen Mary I's short reign, in order that a Protestant could practice their faith without prosecution from the Roman see courts, and so to uphold the principles of the Puritan gains upon the Church of England and the rights established by Henry VIII, who removed the Pope as supreme ruler and so made the monarchy the head of the church. Now, not only did the Bill of Rights finally dilute the power of the Popish faith by creating the rules of succession to the throne, namely, no Catholic king or queen can ever have this right to rule as the monarch, but most importantly, it served to eliminate arbitrary power seemingly enjoyed through the prerogative right of the king or queens over the common law interest to land and those estates administrated thereafter through Parliament. Now, let's just read some of history of James II and causes that led to the Bill of Rights 1688, which of course would secure the position of David Starkey. Now, before we do that, maybe there may be a cause for people to inquire as to why the Bill of Rights is annexed to the year 1688, when the Act did not receive royal assent until the 16th of December 1689. Now, the reason provided is this: due to the chronological timetable adapted through the Statutes of the Realm, Volume 6, 1819, which equate the first year of William and Mary of Orange to be 1688, based on the old Justinian calendar. I don't think we have a full transition until the 18th century to the Gregorian calendar, but it was they're going back based on the old Justinian calendar of when William and Mary of Orange succeeded to the throne, and coupled with the fact that the reckoning of the bills were based on the year that the bill was first introduced and heard in session, as opposed to the date they were passed. So that is why it is now still commonly known as the 1688 Act. Okay, now let's go back to the history on James II. Quoted from the UK government site, James converted to Catholicism in 1669. Now, despite his conversion, James II succeeded to the throne peacefully at the age of 51. Now, not only succeeded to the throne as a devout Catholic, but James wanted to return a heavy-handed approach, which was enjoyed by before despotic monarchies like King John and Henry VII and such. Now, the same article reads, within days of the succession, James announced the summoning of Parliament in May, but he sounded a warning note when he approached Parliament. And yeah, I love you too. The best way to engage me, to meet you often, is to always to use me well. So that was his I would say, hubris attempt at saying, hey, Parliament, you want to talk with me? You better come to me, on your knees, essentially, and then I'll listen to you. James II's iron-fisted, and that was unquote, I'll say, from the best way to engage me, to meet you often, is always to use me well, unquote. James II's iron-fisted attempts were to give civic equality to Roman Catholic and Protestant dissenters and secure the rights of Catholics through his attempt at increasing the size of a standing army through the appointing of Catholic leaders, to which he almost succeeded, whereby during his tenure, and the article goes on, promoted the Roman Catholic cause by dismissing judges and lord lieutenants who refused to support the withdrawal of laws penalizing religious dissidents, appointing Catholics to important academic posts and to senior military and political positions. And in 1688, his second wife gave birth to a potential Catholic heir. So as you see, he was starting to secure his position. So, and the article continues, or the quote continues, and so within 3 years, the majority of James' subjects had been alienated, so transferred into their position. So he was, at that point, gaining a stronghold to which concerned Parliament and to all the things they have achieved and through the people up until that time. And then James II comes in and he starts, hey, no, we're going to change things back to the way I want them to be. Now this leads the English peoples into the Glorious Revolution and the abdication of the throne of James II, backed by Parliament, through the funding of William and Mary of Orange, to take over as constitutional monarchy, which essentially means that the monarchy cannot act without consent of the Parliament. Now I'll read a little capture from the Nature of Rights at the American Founding and Beyond, which sort of surmises it or condenses it best when it says, what catalyst raised rights consciousness in the colonies from its dim 17th century level? Question. Beyond doubt, it was the Glorious Revolution and its enduring testament, the Bill of Rights, 1689. Americans regarded the Bill of Rights as a talisman that patriots had wielded to save England from popery and arbitrary power, and perceived that they, no less than citizens of the metropolis, could wield rights to defeat autocrats in the mist. Unquote. And let's read the Bill of Rights opening, and which then, through its preamble, we can start going into the set of claims that they had that are needing redress from what they had experienced through the heavy-handedness of James II. What do I got? I got the Bill of Rights. Okay, Bill of Rights, 1688. Chapter 2, First Year of William and Mary, Session 2. Is an act declaring the rights and liberties of the subject and settling the succession of the crown. And it reads preamble, whereas the Lords spiritual and temporal and commons assembled at Westminster, lawfully, fully, and freely representing all the estates of the people. I want you to keep that in mind. We're going to get back to that. All the estates of the people of this realm did upon the 13th day of February in the year of our Lord 1688 present unto the Majesties, then called and known by the names and style of William and Mary, Prince and Princess of Orange, being present in their proper persons a certain declaration in writing made by said lords and commons in the words following, namely, and then they list their redresses. Okay, to which now let's jump into a few of those that are pertinent to our study in the English law. First one, or actually Section 2, was the removal of the despotic monarchy. It reads, titled Dispensing and Suspending Power. By amusing and exercising a power of dispensing with and suspending of laws and the execution of laws without consent of Parliament. So, right there is the entry point of no longer can the monarchy act in its own cause without first speaking to Parliament in order to effect any new laws. Then it also, on Section 9, the notice of parliamentary privilege enjoyed today by Parliament and governments. Section 9 states that the freedom of speech and debates or proceedings of Parliament ought not to be impeached or questioned in any court or place out of Parliament. Then they also enact that no one is made subject of the monarchy. It reads, new oaths and allegiances, etc. And it goes on to say, and that the oaths hereafter mentioned by taking or be taken by all persons of whom the oaths of allegiance and supremacy might be required by law instead of them, and that the said oaths of allegiance and supremacy be abrogated. So there it is, the removal of all people being automatically subject to the monarchy. Now the redress of the crown were made legal, and Parliament essentially was given power over the estates of the people. Full stop. Okay. Now let's examine this information through our new law discerning glasses from which we've learned up to this point. Okay. Parliament was noticed through the Bill of Rights preamble, which stated, and I'll read it again, whereas the Lords, spiritual and temporal and commons assembled at Westminster, lawfully, fully, and freely representing all the estates of the people of this realm. What does that mean essentially? All the estates of the people. And so if we now reread the details of the devils leads, the details that the devil leaves subtly in the words unspoken, namely, is to remember subject matter is essential in discovering a correct determination by the courts for a formal and proper remedy consubstantial to the life and status of a person in law. What does the constitutional monarchy only have a right to? If it first has to seek permission of Parliament before decreeing any act concerning the kingdom. So let's now recover of what we've learned this far to ascertain when they speak to all the estates of the people, what does Parliament have a right to? We know that Parliament is a creature of the monarchy. It's an invention of the monarchy and was given the power over the administrations of what itself was granted, meaning over the use only in equity, in which if the 1535 statute uses did not execute the use, therefore creating the common law title or interest, then, sorry, I digressed a little bit, and now I'm going to try to get back into what I wrote. So, given the power over the administrations of what itself was granted, meaning over the use only in equity, in which if the 1535 statute uses did not execute the use, then there must be notice of a trust in operation. And if there is a trust, then at that moment Parliament, through its grant, is with right to administrate over these estates held under an equitable use to land. And so it's through parliamentary privilege that it is noticed to create rules of action over these type of estates, not those held in the common law. Oh, there we go. We just had the prime directive of a cat to jump up on your lap at an inappropriate time and step on your computer and start typing. So now I have to get back to where I was. Don't we love cats? And I'm just fostering this cat, and apparently it knows, the power that it wields by coming in and dismantling, destroying everything. Okay, where was I? I just typed a bunch of things. So, and I don't like to edit any of my videos, as you know. I just go on ad hoc and try to continue on. What we were talking about, as I'm looking for my place, is to remember that the Parliament only has a right to execute those interests and create rules of action over those interests to equitable use, which are subject to a trust. So when they say all estates, predominantly that's what we're speaking about. And so it has nothing to do with the common law interest that is held in the monarchy, does it? Those are correctly, because remember, Everything's separated. Okay. Now, okay. Now, if we are to, and we stay steadfast in the rule of law, that which is created cannot ever be greater than the Creator. So again, monarchy created Parliament, so how can Parliament be greater? It can't. So we can then deduce logically this fact of law, that the monarchy still holds the common law interest to land, no longer as owner because the Bill of Rights 1688, but as fideicommissium with right to hold the land in the interest of the people, who are no longer made subject. They are now free from the despotic monarchy and can choose to leave the kingdom or continue to hold the estates immediately tied to the common law interest, or, subordinately, are those of equity administered by Parliament. I suspect not many, if any, chose to leave the kingdom in the common law or equity law. Now I'm just going to stop before reading on. That's very important. Monarchy or Parliament at that time could not force you into leaving being subject or leave the rights to exercise those positions that were governed by Parliament. That was up to you. It's a very key point. So you still have free will. But I also will go on that if they did decide to leave, which is where we've arrived today, which is solidified in the warranty through the Settled Land Act, that people at that time, there was still much uncertainty, and there still was people that held weapons and can force their will upon the weak. So you would probably want to go and continue to hold land under the monarchy directly subject or under Parliament, so you would gain that security. As we always understand, that your security is generally realized through a group or mob mentality. So they would have then, at that point, purchased those rights to gain security. And we also know that security is another illusion. There's no such thing as it, but there is a sense of it. And that's what drives most of us, and is driving us, most people, like lemmings off the cliff right now, the search of that security, which again doesn't really exist. And we just witness also with the banks as well. Okay. It is then, or so we can surmise by looking to the law and the foundations of subject matter, that the constitutional monarchy has to seek the advice of Parliament when dealing with equitable interest annexed to land only. The common law then was settled, meaning it is in these estates that are the rights or the people that the monarchy holds in the private, and this is held in confidence for and on behalf of each individual when they no longer abstain from exercising their rights realized. And this is realized in Section 106 of the Settled Land Act 1925, to which you can go and look at. Those common law rights were settled, and those interests are secured through warranty, and that warranty is the Settled Land Act 1925, which is we'll get down to further on in our English law series. The Bill of Rights is a contract between the monarchy and the legal personality of government, not the people. So the grant of a right to the use of the common law states held in the right of the monarchy, who holds these interests via operation of law on behalf of a class termed people, whereby each individual is inherently noticed equal in the supremacy of dominion over the land, in which the monarchy then becomes a conduit to secure these agreements on the people's behalf. Remember, the monarchy can do no wrong. It just holds the law, which creates the security for each individual. The Bill of Rights 1688, as a recap, created the rules of succession, established parliamentary privilege, removed people from being subject. The monarchy was no longer owner over all land, but most importantly for our purpose, began the perfection of the law by returning land back into the people, in which separates notice of dominion from those interests in English common law. We are taught today predominantly under the device of government, who regulates its own interest and those who agree, expressively or tacitly, to purchase security according to the interest government has to offer. Okay, and that's bottom line. That's what security is. You are purchasing the agreement that has been amassed, and so that when you purchase that agreement, it is with that security against all those of the same who hold the same type of security. Okay, that's what we're purchasing. You're not purchasing the land, the soil. You're purchasing the agreement, to which then the courts look to the agreement to then find remedy um, towards what you're bringing into court. So we're doing it to ourselves, as I always maintain, that when we bring it to the court, the judge can only effect the remedy subject to that agreement that you're bringing in, and then listening to um, what your claim is, and then go to the agreement to find what is available based on being equal to all those under that same agreement. It's pretty simple when you look at it, and that's why I continue to say the law is perfected. Okay, government took a stronghold in the absence of the people claiming their common law state, and so began its propaganda campaign through offering a welfare-based system to those who were noticed to be in agreement through purchase under a trust for sale scheme as a citizen, aka quasi-trustees, which now the only two estates you can hold under the trust for sale scheme is a fee simple absolute and or leasehold. Okay, all government is doing, namely, is regulating and creating rules for their type interest. That is which is subject to their own power and duty, which means essentially it's removed from each individual's common law interest, which is held in the monarchy, now separated from a trust instrument or through a trust instrument, so as to not ever dilute the value of your rightful inheritance during infancy. They're not touching it. Okay? That's the beauty of fictions. That's the beauty of a trust. It only deals with those matters subject to the trust, those estate interests, and those grants, which are limited to that device. Okay? And as long as you're using that device and purchasing those instruments, you have set in motion the agreement that you want to be protected. When you're ready, stop it. Okay? I can see the cat's ready to jump up again. So I'm going to end this video, and we're going to move on to the, look in the camera then if you're going to sit on my lap. The Act of Settlement 1700 and 1701 is short. And I'm going to, I think what I'll start with is begin with Blackstone's commentaries to set that off. It's going to be a short video, and guess what? From there we can start moving into the Settle Land Act and look into the warranty, I would suppose. Okay, thank you for listening this far. Please like, share if you like these. I mean, I know, and I'm not being hubris or anything to the matter, but being absolute pragmatic in that what I am presenting here is not being presented by, I don't see it, I like to speak to things, as what Ken Wheeler likes to say, which are not discussed normally by the masses. And this is not. No one speaks to the perfection of the law. No one speaks to your true interest, because no one has sought to find out what law is. They capture things and pull things out, and then they jump on that, and whether it's slamming on the pulpit the Bible or trying to bring out, I mean, there is a separation between church and state, yet, there they are bringing in the Bible into matters of law, not knowing what law is, or bringing in matters of equity, not knowing what equity is. Here it is. What is law? Now you know what law is. Can you ever be bribed or taken back and captured back within their system? No. Your true power doesn't exist under government. It exists before government. Okay? And with that, I know that this went on access, but hey, It is what it is, baby.